The purpose of our presentation today is to help everyone understand that divorce is very difficult. However, you do have choices as to how you'd like to navigate your divorce. So these are the options that we will talk about today. There are 4 in particular that we will cover. My name is Nicole Davis, and attorney Jennifer Rench is also with us today to help facilitate our webinar. We'd first like to cover a disclaimer. Our presentation today is for informational purposes only. It is to help all of our attendees understand that they have choices in the divorce process. We will not give legal, tax, or investment advice, but we want everyone to understand that choosing the path to finalizing their divorce is an important and personal decision. We hope that the information we provide today will serve as a starting point from which you can begin evaluating the path you would like to utilize. Today's agenda will include our speaker introductions. We will cover the divorce options, the 4 most popular divorce options. We will give time for questions and answers, and we will summarize everything that we covered, as well as follow up from the webinar with our contact information if you so happen to have questions that come to mind after we've finished the webinar. My name is Nicole Davis. I am a mediator, a certified divorce financial analyst, and a certified financial education instructor. My main purpose is to serve as a peacemaker and a financial security ambassador. So what I do is I help each of my clients navigate the divorce process in a way that protects the parent-child relationship, their businesses, as well as helping both spouses transition divorce with financial security. Jennifer?
Thank you, Nicole. Thanks for having me. I'm really excited about this opportunity to talk to people about their divorce options, because this is what I talk about in my practice, and this is really exciting to have this opportunity, so thank you for inviting me. My name is Jennifer Rench. I am a family law attorney. I am a mediator and a collaborative professional, which means that I've been trained in collaborative divorce. I view myself as a guide for problem solving through your divorce, and I help people produce better divorce agreements through communication, collaboration, interest-based negotiation, and conflict resolution techniques.
Thank you for joining us today, Jennifer. We will move on to, introducing the divorce options that we'll cover today. It's important to understand that in any divorce, regardless of the process that is utilized, there are some things that need to be considered. Obviously, it depends on each couple's situation. However, the issues that need to be resolved in any divorce, regardless of the path that is chosen, are division of property and debt, which would include the division of the marital home, the value of the home, understanding what that is, understanding the bank accounts, what the value of those are and how those will be divided, understanding the retirement accounts, how those will be divided, as well as any sort of tax implications associated with that division, understanding life insurance policies, changing beneficiary names and designations related to such policies, what will happen with the personal property, such as cars and boats and ATVs. There are also considerations for businesses. So there may be a business that is owned by one or both spouses that requires consideration in the negotiation and settlement process. So understanding what the business assets are, as well as the value of that business. These are all considerations. Items such as credit card debt, student loans, and legal fees are also something that need to be talked about and worked through. Other items such as child custody as well as child support need to be understood. Jenny, would you like to expand on the things that should be considered related to custody and child support?
Yeah, I think that most people, when they think about child custody and child support, what first comes to mind is really what is our child custody exchange schedule going to look like, or what is the monthly amount of child support that may be going from one parent to another. But really, when we talk about child custody, in order to come up with a complete child parenting plan, is the days of exchange, the location of those exchanges, whether that's going to be at a certain parent's home or at school or at the child care provider, provisions for vacation periods and holidays, extracurricular activities, and how parents are going to coordinate those for their kids, summer schedule, if that's going to be different than maybe their school schedule, whether travel is going to be allowed out of the state or out of the country, how the parents are going to communicate between them and avoid putting their kids in the middle as a messenger or something. And then also, when we talk about child support, it may not just be some monthly child support figure, but we also talk about health insurance costs and not just the insurance premium, but who pays for uninsured coverages, uninsured expenses that come up if your child goes into the hospital or has to have surgery. Another child expense is college education, or who's going to get the dependent child care or child tax credit on their income tax returns. So all of these have to do with child support and expenses and finances that have to do with the child.
Thank you very much. That's very helpful information. There are other items that often come up in divorce. Such items include the topic of maintenance, which can also be referred to as alimony or spousal support, just depending on your geographical location. And the items that need to be talked about with regards to that is in instances where there's a large difference between the income earning potential of one spouse versus the other. Sometimes it requires that one spouse go back to school in order to obtain their ability to earn more income. So sometimes temporary support of one spouse is necessary, and that should be discussed. Also, just to finalize, what often comes up in any divorce, regardless of the path chosen, is what to do with future disputes. So will future disputes be handled via the court system or via mediation or conversation just between the two spouses? All of that can be discussed prior to finalizing divorce. So we can move on to the 4 divorce options that we will be talking about today. You can see on the screen that we will be talking about the kitchen table divorce, the mediated path, collaborative path, and then litigation. Okay. The first option is the kitchen table divorce. In this process, the couple negotiates and reaches agreements directly with each other. This means that they will talk with each other and come to agreements regarding the items that are related to their particular situation, so regarding their finances as well as the children and perhaps the family business. So it's really appropriate. Well, each spouse can engage an attorney for legal advice during the negotiation. So sometimes couples find it helpful to just bounce ideas off of their own attorney, just to make sure that that they're not missing something in the negotiation process. And then, depending on the situation, what the couple desires, an attorney can be engaged to prepare the final documents as well as finalizing the divorce. So couples may do this for themselves, just depending on the state. Each state has different paperwork requirements and processes in order to finalize the divorce with the court. However, some couples find it helpful to engage an attorney to write up the final divorce decree, final agreements, as well as walk the paperwork through the court and have the judge sign off on it. Some folks really just do not want to be in the courtroom, and it's sometimes simpler, depending on the state or their own individual situation. Sometimes it's simpler for them to simply hire an attorney and have an attorney finalize it with the court. This process, so we'll move on to when this process is appropriate for specific situations. So the kitchen table process to divorce is not appropriate in all divorce situations. This process is appropriate when there is a when it's a low conflict divorce. This means in the situation that the couple is at least amicable and able to communicate with each other at a level that would allow them to have conversations about how to settle their marital affairs. It's also appropriate when there's a presence of mutual trust. This process requires couples to negotiate in good faith and have good faith conversations with one another, meaning each person is transparent and open and honest. Couples, in situations where there's a lower level of trust or where one person doesn't trust the other spouse, even though the one spouse may be negotiating in good faith, the other spouse may not feel like it's a good faith negotiation. And when this happens, it hinders the ability to successfully negotiate a settlement. This is also appropriate for when there are less complex issues. So there are situations in which there are less complex financial issues or issues regarding the children. So you'll see a lot of couples utilize this process when the kids are grown and out of the home, and the husband and wife have decided that they would like to get divorced. So this also is appropriate in situations where there's an equal understanding of the finances. It's important for each spouse to understand the family finances. If one spouse lacks the same level of financial understanding, then they will not know what to negotiate for. So they may not feel like the negotiation is fair, and this could compromise the process. It's important for both spouses to understand the overall picture and have the ability to know what to ask for and what to consider. So this is also a situation where, one or both of the spouses may confer with their own outside professional just to seek a little bit of advice so that they can come back and know what they're asking for. So here are some of the benefits of the kitchen table process. It's less expensive because they're negotiating with each other, and it's usually less complex because that's when it's most appropriate in those situations. Couples also like the fact that they can maintain control. So they can actually maintain control of the process, the timing of the conversations, the agreements, the finalization, usually the finalization of the divorce. They have control over their decisions, and they have control over the cost. There are some risks associated with the kitchen table process, and those risks include the lack of or misunderstanding of legal rights related to the settlement. So This can be mitigated if one or both spouses just confers with their own attorney prior to signing any final documents or negotiating. And the other risk is each spouse is depending on the other to be completely transparent, to gather the necessary information in order to make settlement agreements. So you're really relying on each other to be honest and transparent about all of the family finances and all of the items that need to be considered. The next process that we'll cover today is the mediation process. And in this process, the couple actually negotiates and reaches agreement with the assistance of one or more impartial facilitators present. So the facilitators are referred to as mediators. And since mediators are impartial, this means that they cannot advocate for one spouse or the other. They must remain unbiased. They instead assist the spouses in a way that helps the spouses communicate and reach decisions regarding their individual settlement. The mediator can provide information but cannot provide legal advice or serve as an advocate for one side or the other. In this process, the spouses gather information that is necessary to have a conversation and reach agreement regarding settling the marital affairs. This information is shared equally amongst the two spouses so that everyone has the same information and is able to gain an understanding of the situation before making their wishes known or making a decision. It's called informed consent. The information gathered should help make the conversation productive and should help the spouses make agreements regarding finances, a business, and the children. Once the information is gathered and shared equally, the couple then explores settlement options and they can negotiate the terms of their divorce. Because the mediator is a neutral third party, each spouse can actually confer with their own attorney, finance professional, or therapist in the situation where they're having a hard time moving through the process because they're still grieving the fact that the marriage is ending and they're moving through the divorce. So sometimes they need to confer and seek the help of a therapist to help deal with those feelings and emotions, which is completely natural when going through divorce. Mediation is most appropriate for couples that are committed to resolving their divorce outside the court system. It's also appropriate for couples that may need the assistance of a neutral third party, the mediator, to facilitate the conversation and interest-based negotiation process. So this is really, you may notice that the spouses are talking with one another, similar to the kitchen table process. However, the assistance of the third party neutral, the mediator, can help the couples communicate better together. In many instances, couples have a hard time communicating. Sometimes that's one of the reasons that led to deciding to divorce. So the role of the mediator is to really get the couples thinking and talking with one another, making their interests known so that they can make their options known for how to settle the marital estate. There are benefits and risks associated with this process as well. This is typically a less expensive option for the couple. It gives the couple the ability to engage third-party professionals such as an attorney, a finance professional, or a divorce coach or therapist. This is private and confidential. This is very important because the fact that it's private and confidential means that the couple should feel safe in being able to let their interests be known, provide information that's necessary to negotiate and to come to agreements on settling family finances or the business or making decisions about the children. The information that is shared is not supposed to be, used against the other spouse later on. So that's a really important component of mediation, and that's one reason why mediation is very effective. This also allows the couple to maintain control. It allows the couple to maintain control over the process, the conversation, the timing, and the decisions. This is a more structured negotiation avenue than the kitchen table option path, because there's a third-party facilitator that's helping the couple move through the process. There are risks. Risks include situations where there is substance dependency, so where there are issues with substance abuse or alcoholism or any issues such as that, as well as mental illness, domestic violence, or power imbalance. So in situations where those things exist, it doesn't mean that if anything like that exists, that mediation for sure will not work. However, it does pose a risk because if someone is not able to understand the process or be able to engage in a neutral and fair conversation, they're not able to then advocate for themselves. And they need to be able to advocate for themselves in order to make consensual agreements. Sometimes debilitating emotions will impair the ability to negotiate and have conversations. So sometimes one spouse or the other is still grieving the fact that they're going through a divorce. And when I say debilitating, that means they're not able to make decisions about settling the marital estates and making agreements because they're still dealing with their emotions. It doesn't mean that mediation doesn't work. It just means that perhaps the one spouse needs to find a way, working with a divorce coach or a therapist perhaps, to recognize those feelings, work through those feelings so they can come to a place where they can move forward and start making decisions and gaining agreement. Again, in this process, the spouses are dependent on each other being completely open and transparent with all of the information so that each spouse can make good decisions based on the best information. Okay, the next option that we will talk about is collaborative. Jenny is going to cover collaborative as well as litigation.
Okay, so I think all the information that Nicole shared is very good and very valuable. They are different processes, and I kind of look at them as each process we're going through adds a little bit more support. So collaborative is really like a step up from mediation in level of support, where in mediation you have just one third-party balanced facilitator. In the collaborative process, each spouse is represented by his or her own collaboratively trained attorney. And that part's important because anybody can go out and hire their own attorney to negotiate on their behalf, but to be a collaboratively trained attorney, there is a particular training that that attorneys go through that helps them with interest-based negotiations and conflict resolution techniques. and these attorneys have been trained to work together, not on the same side because they still maintain that attorney-client relationship and privilege with their own client, but you know entering to a real collaborative process that you're going to have two attorneys that at least aren't adversaries to each other, maybe had a bad case together in the past and they just don't like each other, which sometimes can really hinder a process where, the clients are more willing to negotiate, but the attorneys sometimes in their style can be an issue. Or so a couple can, in the collaborative process, a couple can add one or more additional professionals to their team. Nicole mentioned a divorce coach, and a divorce coach would help the couple improve their communications so that when they come to the negotiation table, they're able to articulate their wants. Of course, the attorneys are there as an advocate sitting at the table with the parties now. In the past methods, nobody is sitting at the negotiation table with the parties. The parties are advocating for themselves, but in the collaborative process, you have the benefit of your attorney advocating for you. The divorce coach if you have one divorce coach, the divorce coach acts as a neutral. Sometimes people involve two divorce coaches, but the divorce coach can also prevent negotiations from stalling by keeping a wrap around the process and keeping emotions in check. Sometimes there are particular child issues like special needs for children or other child issues where a child specialist might get involved. And a financial professional can also be utilized in the collaborative process to help the couple gather and understand assets, debts, and other financial information. And the financial professional would also help create financial settlement options depending on the future goals of the parties. And really, involving other professionals in your divorce besides an attorney is not really a foreign concept. It's not a concept that's unique to the collaborative process, because if you think about it, in litigation, we may have a guardian ad litem representing the kids, or we may employ an accountant or a CPA to give an expert opinion on the financials, or have a psychologist give expert opinion on the mental health of a party or of the children. But the difference really is that in the collaborative process, all of the professionals are employed, who you choose to employ in this process, work together as a team to problem solve and to help the couple reach out-of-court agreements rather than to, offer competing testimony in the courtroom in a litigation setting. So from the very beginning of a collaborative case, the parties agree to use all of their efforts to reach a settlement, which works for both them and their kids without going to court. Most of the work in the collaborative practice gets done in a series of meetings. So sometimes the parties will meet privately with their collaborative attorney or other professional, and the parties then come together in a series of joint meetings that are designed to produce open exchanges of priorities and expectations, followed by good faith negotiations. In the collaborative process, workable options can be found and disputes are resolved without burning bridges or threatening important relationships. The collaborative process minimizes hostility by emphasizing compassion, understanding, and cooperation to resolve their mutual circumstances. And many couples are able to settle their family law matters out of court, especially with the assistance of professionals who have been trained in conflict resolution techniques. So this method is appropriate for couples that are interested in working towards settlement outside of the court. It's also appropriate for couples that would benefit from a team approach. So again, as Nicole talked about, mediation, and you can employ professionals outside of the mediation process, but then really you're coming back to the table to advocate on your own, which can really work for some people, but some people really need their professionals to work as a team in order to come through and reach agreements for their divorce. Collaborative divorce is also appropriate for couples that want to remain in control of their decisions, the timing, and the cost. So you set these joint meetings on a schedule that is appropriate for how you are moving through the process and how quickly you need to make decisions, or sometimes, you need more time to gather information in between joint meetings. So all of that is decided by the two parties who are involved, and is set that, in a way that's appropriate for your situation. And you also maintain control over the costs, because as you set these meetings and you can space out the costs in a way that makes it affordable for you in your situation. And divorcing parents, it's also appropriate for divorcing parents that wish to maintain a positive co-parenting relationship post-divorce. And this is possible because if you've chosen the collaborative process or any of the other non-adversarial processes, you really value and understand that just because your marital relationship is ending, if you have kids, your relationship as parents still needs to continue. And when you go through an adversarial process like litigation, it can be very damaging and draining on that relationship. So the collaborative process is appropriate for people who understand that maintaining a positive co-parenting relationship is really important. So we've kind of touched on some of the benefits, but we will talk about the benefits of the collaborative process. I just mentioned that it minimizes conflict by utilizing professionals who are trained in conflict resolution and interest-based negotiations. And that's good for people who are trying to maintain a co-parenting relationship after the divorce. Collaborative process is a private and confidential process. So your family's problems and finances are kept private inside the process. All the discussions are confidential within the collaborative process, and there's no evidence that's presented in a courtroom, or there's no depositions where you're going to be put on the spot. It is, you maintain control. There's no typed transcripts that are going to result from the discussions that you have inside the collaborative process. You also maintain control of the timing and frequency and the length of the meetings. I talked about that. The collaborative process is an organized process. So most attorneys that practice collaborative divorce are usually part of local groups, and these groups of collaborative professionals have protocols that really enshrine best practices and guides that the professionals and the clients use throughout the divorce process in kind of a choreographed manner. So the collaborative process the collaborative professionals are all on the same page when it comes to forming a collaborative team or beginning working with a family. Other benefits of the collaborative process include the focus of the process is really to look at your future. And the collaborative process seeks to ensure the long-term well-being of all the parties that are involved. And that is possible when you pick the appropriate process for your situation. When couples agree on financial and parenting outcomes, they tend to return less frequently for modifications because they got it right the first time. And when changes are needed, they're more likely to cooperate in negotiating an agreement upon change. This is because the collaborative practice is designed to be more creative and adaptable than traditional litigation. And collaborative practice is designed to identify interests and meet the needs of the interests of the parties involved, rather than just focusing on wants or positions of each of the parties. Using a professional in their own wheelhouse also really maximizes the efficiency of your time and your resources and your money, because that professional is really best equipped to tackle whatever issue that is. So the attorney is best to tackle the legal aspects of the divorce, while the coach is best equipped to tackle the emotional aspects or the child aspects of your divorce, and a financial expert is best equipped to tackle all of those, your assets and your debts and options for how to divide those. And because the coaches keep check on the emotions, it keeps the progress in the collaborative process from stalling or breaking down. So that's a time saver. Some of the risks associated with the collaborative divorce is the collaborative divorce does typically cost more than a kitchen table divorce and mediation. And when I say costs more, I just mean in financial terms, because while mediation is a shared cost, and sometimes kitchen table, if you have an uncontested divorce, maybe you're not paying for somebody to represent you at that point. But when you talk about some of the non-financial benefits to the collaborative practice, as far as having a more durable agreement or involving professionals that are really well equipped to meet the needs of your interests, that has an impact on your future, those costs, although not financial or maybe immediate, really can affect and impact the cost of doing it wrong, I guess, when you don't pick the correct method for your situation. So really having the right amount of help at the table at the right time keeps the process from stalling, leads to a better income, and can be less costly. And one of the other risks of the collaborative process, again, like any of the other voluntary processes we've talked about, if one party negotiates in bad faith, it really undermines the process. And although, we kind of have checks in place to see when that's happening, it is a voluntary process. And so if one party is negotiating in bad faith, it's really hard to get some kind of an agreement or appropriate agreement in the collaborative process. In the collaborative process, since it is an out-of-court method, there is no formal or enforceable discovery methods. Like I've said before, it's really based on good faith negotiations between the parties. You may not have all your agreements put together, but at this point, but you know that you want to use a process that's out of court in order to make those agreements. That's the commitment you need for, collaborative process, mediation, or kitchen table divorce. So all three processes that we've talked about before, the similarity between all of them is that you would reach agreements before ever filing anything in court. I know that that's not true sometimes for the collaborative process in different states around the country, but most of the time you are going through the agreement process before you're filing anything in court, or at least you are filing something and then doing the agreement process totally outside of the courtroom. But in litigation, it's different. So we're going to go to the last option that we've talked about, and that is litigation. So the process, the appropriateness, and the benefits and the risks. Litigation is a process where most couples start, unfortunately, because that's usually the only way that they've learned or know how to divorce. And that's why Nicole and I are really excited to present some more information to you so that maybe it'll get your wheels spinning about maybe there's another approach that we can utilize to figure out the agreements in our divorce. But in litigation, litigation is an adversarial process, and the parties rely primarily upon the court system and a judge to resolve their disputes. So the beginning of a litigated divorce starts with the filing of a petition, requesting the divorce, and filing financial statements, proposed parenting plans, and then, along the way we file motions and formal requests for documents and answers to questions. So in the litigation process, communication between the spouses, which may not have been too good at the time of the separation, usually gets worse because the negotiations usually take place through the attorneys. So the attorneys may exchange written settlement offers or may talk to each other, but it's really kind of like the telephone game, I'll say, because, wife will tell wife's attorney something, and then wife's attorney will pass that along to husband's attorney, and husband's attorney will then relay that to the husband. And the messages kind of go back and forth, like you can see on the screen. It's going back and forth, passing between the two attorneys. And really the two most important people that are involved, the husband and the wife, or the two wives or the two husbands, they are really on the outside of all of this negotiation. So communication does not certainly improve between the two parties that are separating. But each party really focuses on their own positions and past bad behaviors of their spouse to bolster their own story. And litigation can often be thought of as a zero-sum game because you present your case to the judge, and the judge says one person wins and one person loses that issue. So in litigation, you often come to view each other as adversaries, and your divorce may be a battleground. If a settlement is not reached in litigation, then the judge has the authority to make decisions after a trial. After a trial, post-trial motions and appeals are available if either spouse is not satisfied with the judge's decision, at a cost, of course. And the resulting conflict can really take an immense emotional and financial toll on the family and can be especially damaging to children involved. But litigation is appropriate in some situations. Litigation can be appropriate for couples that are unable to work together in any of the other voluntary out-of-court processes we've discussed. Litigation can be appropriate for couples that need a formal discovery process regarding conduct of the parties or finances. So Nicole talked a lot about transparency and good faith, representing things in good faith and bringing information to the table. While in litigation, some people need to use that formal discovery process and the judge's authority to hold people to that process. In litigation can also be appropriate for people that need the enforceability of temporary custody or financial orders. So it is possible to ask the court for a temporary order before the case is over if there are immediate issues that need to have a resolution immediately, and it has to be enforceable. That's not to say that in any of the other processes you can't come to temporary agreements, but litigation would be appropriate for people that need the enforceability of those temporary agreements or orders made by the judge because maybe their spouse is just not going to follow through. Benefits of litigation is that there are rules that outline a formal discovery process. The process is costly and lengthy, but the judge has the power to enforce the rules. Some of the discovery techniques include depositions, which requires the expense of a court reporter and your attorney's time to prepare and hold the deposition, drafting requests for the other party to produce certain documents, and issuing subpoenas, which requires the expense of preparing them and serving them on the other party. If the couple cannot make decisions, another benefit of litigation is the judge has the authority to make the final decision, and that decision is enforceable. So when it is impossible to make agreements through any of the other processes, then somebody's got to make the decision. There has to be some kind of finality, and so the judge has that authority in litigation. During the litigation process, as I talked about before, the judge also has the authority to issue temporary orders. During settlement conferences, the attorneys can informally talk to the judge about the facts and the issues to get the judge's informal input, which is a benefit because it's sometimes helpful when neither party is willing to budge on their position. The actual parties, though, are not involved in or a part of these discussions, at least not here on this side of the state of Missouri where I practice. So some of the risks of litigation is that the parties involved in litigation can really lose control over the outcome of their divorce. If you can't make an agreement, a judge who is a perfect stranger will hear your life basically condensed into maybe a day's worth of testimony and evidence, and then make a final decision about the future of you and your kids. And sometimes it is an outcome that runs down the middle of what either party presented as their case, and so really you end up with a result that neither party wanted. A judge couldn't also possibly address all of the issues at a level of detail that most people need to end up with a complete agreement. And the judge simply won't know enough at the end of a trial to really craft tailored solutions. It's not really their role. A judge is there to decide on the law and is bound by the constraints that the law sometimes has on the outcomes he or she can order. So the other risk is that scheduling of your case is based on the court rules and the judge's calendar. So where I practice, usually unless emergency motions are filed, you normally won't have your first court date scheduled for 3 months after you file your case. And if you end up in trial, it could be 6 months to a year before you have a trial date at all. And then if either party files an appeal from the judge's decision following a trial, well, then you're really talking about an extremely lengthy and costly process. So, statistically, really 95% of couples that file for divorce end up settling a case anyway, regardless, of whatever process. It just really makes sense to me to consider a process that's focused on reaching a settlement from day one that will lead to a better outcome. So that's why people are really pleased sometimes to learn that there are more options than alternatives to litigation.
Great. Thanks so much, Jenny. This is very, very good information. So now we will move on to questions and answers. If anybody has any questions at this time, we will take them.
I actually have a question that comes up. A lot of my clients ask this. Why should they use a certified divorce financial analyst in their divorce process?
Well, that's a great question. Many folks do not even know about certified divorce financial analysts, also referred to in some parts of the country as divorce financial planners. But the main reason why couples should use a divorce financial analyst in their divorce process is because there are significant financial ramifications associated with decisions that they make when they make decisions or agreements regarding the marital assets. Things such as the home, investment accounts, a family business. There are specific tax implications related to how couples divide those assets, as well as the debts. So when one looks at, well, a home is worth $200,000 and the investment account is worth $200,000, they equal each other. Well, they really don't, because investments have oftentimes tax implications with it, whereas the family home, if sold, doesn't, and if kept, can the spouse that wants to keep it really afford to live in it? So all of those considerations are discussed, analyzed, and the information is presented to the couple in a way that makes sense and gives them the entire financial picture related to their divorce settlement options.
Thank you. That makes a lot of sense, and I try to share that with clients, but you say it so much more concisely than I do. So.
Well, thank you. That's a great question. Jenny, in your experience, what are some of the feedback associated with clients that have used alternative, meaning outside of the litigation avenue, for divorce? What sort of impact has that made on their life?
A lot of people that are going through divorce, no matter how skilled or how much an attorney communicates with their client, a lot of people going through the litigation process, I often hear them say, I don't understand what's going on. I don't understand why would the judge do that? Why would they say that? That doesn't seem fair. They want their story heard. They want their day in court, and it's incredibly frustrating when you have to say, okay, well, we're scheduled for 3 months from now. So it can be a lengthy process, and really the start of it of any litigation process is a bunch of information gathering, but you are only working with your client, and so it seems that for the longest time, all we're doing is talking back and forth about financials when really they're chomping at the bit to start resolving stuff, and it's a process. So to answer your question, the people who choose a different divorce method are much more satisfied because it's much more transparent. They can see everybody involved. They can see that their spouse is doing something. You know, they're not just hiding in their attorney's office, you know, doing stuff with just their attorney. It's really hard to tell them, well, there's a lot of work that goes into preparing those financial statements, which are only 3 pages long,
right.
But we had to gather a box full of documents for that. So they are more satisfied from the get-go because they can see progress, whether that's little or you know, moves pretty quick. But they are also more satisfied with the outcome because for a couple that is separating, they have a hard time. They may have had a hard time in their relationship or in the, you know, in recent times really hearing each other. And although we don't, you know, this is not a counseling session or, you know, something like that, the power in listening and hearing somebody else's side really can break down the walls to a better outcome for you because it leads to solutions that we didn't think were possible or we didn't understand because they weren't being articulated clearly. So it's a better, it's a more satisfying and durable agreement, and they're more satisfied with the value and the cost of it because they feel like it's not going to be a runaway expense, you know, whereas in litigation a lot of times you're paying check after check and you stop at one point and you think, where is all this money going?
Right.
Why are we doing
Right.
this?
We're no further down the road than we were 3 months ago, but
because it's so hard to see progress. And
in that process.
Yeah.
Yeah. How many? Speaking to the alternative methods to divorce, I wonder how many times it could be counted when folks say, I didn't know you felt that way, or I didn't know you thought that, or, you know, just misunderstandings in general. That's great. The beauty of the other alternative 3 methods is when it really, like you mentioned, helps the spouses communicate with one another.
Right. Yeah, and you covered mediation, and really, you know, the mediator is so important for spouses that maybe don't need the level of support of maybe the collaborative process, because that mediator, sometimes their big role is just clarifying. Sure. Because somebody can say something to you and you hear it one way, but if the mediator can reframe and rephrase it, it really just opens up the possibilities to a win-win outcome. Because that's really the goal. You know, I explained in litigation's really a zero-sum game. You either win that issue or you lose that issue. Right. But there is potential and an opportunity for both parties to get what they need out of a divorce. It just has to involve enough communication and enough and the appropriate level of professional support to you know, open those possibilities up. Right. Yeah.
That's a very good point. Well, thank you for going over the collaborative process and the litigated process. So just wrapping it all up, right? Summarizing everything we've talked about today. Divorce is a very personal experience, and it is unique to each couple that is going through divorce. And oftentimes, understanding that they have choices regarding the path that most fits their individual situation gives them a sense of control over the process, the decisions, the agreements, and the costs. And with that comes, they get to reframe how they transition the divorce and move positively into the next chapter. So hopefully this presentation has given you great information regarding the different paths to divorce, and that you do have a choice when it's appropriate, as well as the benefits and risks associated with each option. We will send you our contact information should you have any questions after this webinar that happen to come to mind. And we just really want to thank you for joining us today and allowing us the opportunity to share this information with you. We hope it's made a difference, and we hope that you have a great weekend. Thanks, everyone.